Hey guys, Kristen Marks here with My Pink Lawyer, and I want to answer a question that comes up a lot. I guess it's more of an issue that I deal with often when I'm meeting with clients, and that is, why can't I have my child on my bank account with me? So a lot of clients come in, and as part of their strategy session, I have them fill out an estate planning worksheet before they come in so that I can review it in advance and make sure that we are well prepared and save our time together. And one of the things that I'm looking at is, how do they own their assets? Who actually owns their assets? Who is on their bank accounts? Who is on the title to their real estate? And sometimes I will discover that a client will have an adult child on their bank account with them. And 99% of the time when I ask them, why is your child on that bank account with you? It is for convenience purposes. So it's some variation of that. Convenience purposes, hey, if I'm in the hospital or I'm traveling or I otherwise need my child to pay my bills for me, write out checks, they can do so because they're on the account. Unfortunately, there's a lot of downside to having your child on your bank account with you. So let me go over some of the biggies that I see as a reason not to have your child on your account with you. The first one is liability. If your child gets into a car accident, gets sued, files bankruptcy, maybe even files divorce, or in the middle of a divorce, then your bank account could be subject to paying that child's creditors. That is horrible. So your kid goes out, they accidentally run over somebody, they have a big judgment against them, insurance is not enough to cover the catastrophic damages. That plaintiff's attorney is looking for easy money, and cash in the bank is easy money. And if your child is on that bank account with you, the presumption is that the money belongs to your child just as much as to you. So you have to go to the trouble then of defending yourself and going to court to prove that the money is actually yours. So that's not good, any way you slice it. The second reason it's a bad idea to have your child on your bank accounts with you is because it could affect your child down the road. I met with a client recently who is in the process of applying for Social Security disability benefits. He is no longer able to work. And unfortunately, his application was denied because he is on his father's bank account. Those assets that he has access to, even though it's not his money, he can access the account, makes him ineligible for benefits. So that's not good either for my particular client. The third reason it's a bad idea to have your child as a co-owner of your bank accounts with you is because you're basically giving your kid carte blanche to your money, right? They are now a co-owner of the account. They can go in, do whatever the heck they want to with the money, and it's presumably theirs. It's going to be very difficult to get any money back if your child were to steal money from you or otherwise mishandle the funds because, hey, you trusted them enough to put them on the account in the first place. Another reason it's a bad idea in a lot of situations to name your child as a co-owner of your accounts is because when you die, the bank account continues to belong to that one child. If you have multiple children and the intent is to divide the account among all of your children, the person on the account does not have any legal obligation to share it with their siblings. Even if your will says to do so, the ownership of the account trumps your will and the money belongs to your kid. Well, you might be saying, well, my child's going to do the right thing. Well, of course, my job is to play devil's advocate and say, no, they're not. They're not going to share the money with their siblings, but let's assume they even did. If it's a large enough amount and the child does share the money with his or her siblings, that is considered a gift now from the child to their siblings, and they might have the burden of having to file a gift tax return with the IRS to disclose those gifts. Oh, what a headache. So, how do we get around this? I have good news. There is a workaround, and it is this. Remove your kid from your bank account. Now, it will take your child also agreeing to be removed, unfortunately, but remove your child from the bank account, put it back just into your name. Sign a power of attorney. You can name that same child, giving them authority to help you out with your banking affairs. Give a copy of that power of attorney to the bank. That child can continue to pay bills on your behalf out of your account and help you manage the account. Then, if you want to avoid probate of the account when you die, sign what's called a POD, Payable on Death Beneficiary form with the bank for that account, naming whoever you want to inherit the account upon your death. That might be the one child, it might be all of your children. That is called a POD form again, Payable on Death Beneficiary form. Some financial institutions call it a TOD form, Transfer on Death form. By signing that form, you're naming beneficiaries for the account. All the beneficiaries will need to do is present a death certificate after you die, and the account will be dispersed among all of your beneficiaries. If you have questions about this or anything else related to your estate, and you are a Florida resident, of course, we would be more than happy to help you out with your planning and answer your questions here at My Pink Lawyer. And you can get more information from our website and reaching out to us at mypinklawyer.com. And if you haven't already ordered a copy of our book, please visit pinklawyerbook.com to reserve your free copy today. Thanks a lot.